before the court is State of Ohio v. Michael Simbo. The state has waived their argument, so we just have the appellant here. You will have 15 minutes to present your argument. Please stay behind the podium. As you know, the arguments are being recorded. Keep your voice up. You should not use the names of children or minors or victims. The judges have read your brief. We're ready to proceed when you are. So Attorney Kudachip, if you would like to begin.
Judge Carr, Judge Sutton, Judge Lansing. May it please the court, I am Richard Kudachip. I am court-appointed counsel for Michael Simbo. You know, I thought it was important to come here today. The state didn't think it was important to come here today, obviously. I have two thoughts that really troubled me when I started looking into this case. The question really being, was this an intelligent plea? Was this one that was voluntarily and knowingly made, but with intelligence? And secondly, and the state would probably say, well, we have another defendant who's dissatisfied with his sentence. When we remove the presumption of concurrent time, did the trial court provide sufficiency? Did it provide foundation for removing that presumption and giving a harsh sentence of consecutive time? So yes, this was a terrible accident, but it is also critical for the court, for all of us to look at, this is a reckless case. This is not an intentional case. And that distinction is important. If it were to be said to be a negligent case, it is also very critical to identify that there is no intent in the behavior claimed in this particular indictment. So we have a young man, Michael's a young man, 25 at the time, hanging with people, probably not whom he should be. But when you look at the accident, and it's clearly defined in the PSR, it was a high-speed chase, apparently. I don't know the length of time, more than 8 minutes, resulting in an extraordinary tragedy. And there's no doubt about that. But when we look at penalty, when we look at the process here, Your Honors, here's a number of things that I don't think were sufficiently identified. First of all, Michael came forward and there was acceptance. The state agrees that there was acceptance of responsibility. He did give an interesting account in the PSR. I do not know why. I don't know how counsel treated that or helped him with that. But he pled guilty. By the way, when my client was talking about having a gun to his head, and the state saying there was no gun, it should be also important to note there was a holster found in the property. So at least there was some semblance that can give credibility to my client's statement in the PSR.
But that was attributed to your client, though, also, wasn't it?
What's that?
The holster, wasn't that attributed to your client?
It was. But then who knows? There's no sufficiency in the weight of that evidence as to whose it was. That was the claim from the Ohio State Highway Patrol, I believe. The second...
That because there was a plea.
Yes. The process is what I'm asking the court to scrutinize here. The second thing that's important, there's no prior history of Michael, so he had nothing before. The PSR expressed sincere remorse. He clearly made remorse a part of his allocution at sentencing, his sorrow for the victims. He had nightmares. He wanted forgiveness. And there's another important thing that's critical, because what I'm saying here, the discussion of mandatory time was not sufficiently made either by the trial court or by counsel. And how's that demonstrated? When Michael was asked what the penalty should be, in the PSR or otherwise, he said probation. He didn't say, I have to serve mandatory time. So we have reduction from F2s to F3s, and I asked the court, what benefit did my client get from these reductions? And I don't think anything. I don't think the government could prove that my client was under suspension, for one thing. So F3s were probably the appropriate result here. But when the court came through with sentencing, it did not provide sufficient support for and requirements under criminal rule, to provide for consecutive sentences. So let's take a look at the mandatory time. And by the way, one of the other things the state probably isn't here for, they can't rebut my arguments, what I'm saying today, or what I've said in my brief. There is insufficient discussion in the record about mandatory time. So let's look at the process here. I mean, neither the defense or the state talked about mandatory time on the record. Now, there's nuances, or there might be some referral to it. And yes, we're going to blame a little bit. We're going to blame COVID here a little bit. Because we have 506 days of my client in detention, pre-trial, pre-plea detention. And we also have, according to the record that I can see, there was no live contact interview with counsel and Michael Simbo. So when we look at that, and likewise with the trial court, not to fault the trial court, because the trial court was under extreme pressure, just like all of us in the legal community, regarding how to deal with all these matters under COVID restrictions. But the confusion between the defendant and the process is demonstrated everywhere in the record. I mean, the state says in its brief, well, let's see, counsel acknowledged imposition of mandatory time. Well, so what? And if that be so, when was it said? Read also what counsel said in August 4th, 2022. The original negotiations talked about non-mandatory time. The original negotiations talked about judicial release. The client's hearing all this thing by video, not in court where they're, he can say, hey, lawyer, what's that you're saying? So when you hear all these things that the counsel is saying on the record relative to these matters, you see confliction, you see confusion. And I think when you put the totality of this record, and it will support my argument that the confusion is there. I mean, take a look at the plea hearing. So we have a plea hearing, I believe it was May 13, 2022. So the trial counsel files a motion saying there is discovery issues. Then all of a sudden, at the same time, there's a plea. And critical in that plea, the court has to address, to determine that the plea is made knowingly, intelligently, the court must first address the defendant, the nature of the charges, the maximum penalty. Here, mandatory time is a critical penalty.
Counsel, just so I understand, my understanding of reading the briefs and so forth is that, like you said, it was a last-minute type plea, although they said that it didn't work for a good while. But they had a preliminary, and I don't mean that in the sense of preliminary hearing, but a preliminary hearing before the plea was actually entered into. And at that point, that's when you're saying, and I think the state says, that mandatory time was discussed by the attorney, and she indicated that the defendant understood. But your argument is, and I'm not sure the state contests this, is that when the actual plea was entered, there was no mention by the court, no advisement whatsoever of mandatory time.
That is very correct, and that is my most significant premise here, because that does not follow the rule, doesn't follow the requirement. And we might say, so what? So he's going to go back to court and he's going to do the same thing the judge will tell him. Well, that's not right. We don't know until we get back there what he will do, because I think the confusion that's demonstrated, take a look at the PSR. The PSR says clearly that, he thinks probation. He's thinking probation here. So this is prejudicial. Here, the trial court simply failed to explain those rights in the exposure. The Supreme Court State v. Clark, urges literal compliance in sentencing. And again, I feel sad, making negative comments to the trial court, who is a tremendous jurist. But when you look at the times, you look at what was going on, the pressures, an easy mistake like that might be made to assume we're talking about understanding mandatory time, but it's up to the court to determine intelligent, I should say, a plea, and that did not happen. Criminal Rule 11C2, court must determine the voluntary plea. Now here's another thing that was not said on the record, and it's critical. The court must advise the defendant that he or she is not eligible for probation. Again, that did not happen here. So the
It
record...
also seemed, as when I was reading the transcript, it seemed like there also was a little bit of confusion in regard to when the court was trying to advise the defendant about his eligibility for judicial release.
I think there was indeed, and if you take a look at the sentencing colloquy, you will find voids and gaps in how advice should be made. And I think that belies the requirements under 11C2. In fact, the state concedes that the trial court did not specifically state appellant was ineligible for community control. That's at page 9 of the brief.
Did the court say you have mandatory prison time associated with these offenses, because doesn't that say you aren't eligible for probation?
It does indeed, Your Honor, and that's precisely why it's important for the trial court to advise a plea defendant. So here's the thing, because I know that, at least two of my judges today have been sitting as sentencing judges time after time. So we know, and so for us lawyers who sit there and watch, colloquies, allocution, and then sentencing, how important it is that the colloquy is sufficient, defined, specific, and according to rule. Because only then the requirement of the court can be met to determine that it is an intelligent, voluntary, and knowing plea. The court must determine that at the time of sentencing, not over the totality of the record. And I think when you look at the transcript and it talks about trial counsel talking about mandatory time, it's way, way long before the plea hearing. And so this is plain error. It's clearly prejudicial. It's not clear that Michael would have pled guilty. Whether he would or not, we can surmise, but it's not clear. And that, I think that prejudice is significant because the court didn't substantially comply with it. Here it's an unconstitutional plea as a result, and the totality of the record demonstrates that there's a lack of clarity in the plea negotiations that my client could understand. He wanted non-mandatory time, judicial release, that was the negotiations, the reduction to the F3, and with all that period of time. I would like to talk a little bit about consecutive sentencing. So I urge the court to look at page 29 of the sentencing transcript. That transcript, the court says, this is a tragic case. The film, the videos were shown. It's awful. 2 people were killed, another injured. Mr. Simbo's actions put law enforcement at risk, all of those people out doing their jobs. Then it says the court has considered the plea agreement, and we talk about boilerplate language here. And that's it. There's no support in the court's findings in this record that supports that my client is a danger to society. This is a one-time event for a young man with no client, who had with no prior history, who had a bad record, and it gets 11 years throughout consecutive time sentencing. Tragic, but does the public need to be protected in this instance? So when you have a first offender, unlikely to happen again, not a course of conduct. This is the same conduct in the same period of time. It all happened at once. Same thing with the failure to comply and the homicide and assault. So this court
But
needs...
multiple victims, correct,
Yes,
for each count?
correct. And that's where the 3 counts came egg harm for 2, egg salt for 1, and then the failure to comply. So I get it, there should be a sentence for that. My client understands that, but consecutive sentences are not supported in this record. This court must review the record and the findings that support. So I get it. In conclusion here, sentencing, if it falls within, what do we come here to talk about? And I say we come here to talk about when it gets to removing a presumption on consecutive sentences, let's require the trial court to make at least some findings to demonstrate that the person is a public risk, or indeed that the findings are compliant with the law, not boilerplate language. And consecutive sentences here are simply not supported. I'm asking the court to reverse that and make the court's decision that a consecutive sentence should not be made in this case. If there are no further questions, that's my presentation today.
Thank you, counsel. The court will take the matter under advisement and issue a decision in due course. On the day that the decision is released, the clerk of courts will mail a copy of that to you. The opinions will also be posted on the Ohio Supreme Court website. Thank you.
Thank you, Your Honor. May I thank the court for its attention to my client, Michael Simbo.